still under group 6, my lord. Lordship, may it kindly be listed.
Give it for inclusion.
Item number 1.
For one, my lord, I am for the petitioner, my lord. I have served, my lord, all the respondent, my lord. You know, my lord, state respondent, only for state respondent. This is my affidavit of service, my lord. Regarding my lord, shortfall of service, my lord. My lord, I challenge the region order passed by the respondent authority, file a way application before the state administrative tribunal that was not disposed of, that is still pending. So, my lord, I came before your lordship, my lord. During the pendency of the, my lord, the way application, my lord, the sole petitioner.
Lordship, may I be permitted to check on matter?
Sole petitioner died, my lord. So, my lord, the legal year of the petitioners, my lord, filed this application before your lordship, my
What
lord.
is the pending claim?
Pending claim is, my lord, is, the shortfall of service, my lord. He is not qualified. My past service was not calculated. 1972, petitioner was working for the state.
What is the date of his regularization?
Yes, my lord. In the year, my lord, 1996, my lord, retired from the service 2004, my lord. My lord,
He retired in 2004.
yes, my lord. My lord, they have the application that was considered, and my director, the responsibility to consider, they consider rejected. Against that, my lord,
What do you want?
my lord,
What is your
pension, my lord, regarding pension, my lord, pension,
Why you are not getting it?
my lord, they have not completed, my lord, 10-year qualified service according to your calculation, my lord. I am working for the state post, my lord, 1972. My lord, my
Therefore, we ask you, what is the date of your regularization?
regularization to 1996, my lord.
Where is the order?
Yes, my lord. Kindly see the reason order, my lord.
Sir, where is your regularization order? How many times we have to ask you the same thing?
Yes, my lord. My lord, kindly come to, my lord, the page 40, my lord. My lord, as per the government circular, it was regularized, my lord. Page 40, my lord. My name was there, my lord.
How many? There is one petitioner.
Yes, one petitioner, my lord.
No, this is not a regularization order.
My lord, kindly come to page 4K, my lord. 40K, my lord. My lord, page 40, my lord, the order, my lord. Robi Dule, my lord.
Where is your regularization order?
Page 40I, my lord. It is the order, and my lord, next page is appointment letter, my lord. My lord, the page 4J, all, my lord. The official order, my lord. Official order.
No, that office order is of 81, 82, much prior to this 1993. What are you trying to show?
Kindly come page of absorption of seasonal khalasi as a seasonal male role in the labor. My lord, kindly come to, my lord, last page, my lord. 84.
The reducer.
Regularization, the period of service can be counted for the purposes of qualifying. In that case, here it is different. Here it is ordering the services prior to declaration. That is covered by provision. DCRP and service. Which is that if someone after renting past services shall be counted. So, certainly whether he had to qualify service for eventually. Where is the revised unless he has searching this release. Where is your regularization?
Regularization order is not annexed.
Then how you will get a pension?
Yes,
you are
they have admitted, Malad. It is admitted back, Malad.
Then why you are before us? If it's all admitted, then there is nothing.
Yes, but Malad, they have Malad. They kindly see the region order, Malad. They have admitted in their
Page.
Malad. Is Malad 128, Malad. The communication letter, previously, the region order is page 125 and said, yes, my lord. 125, region order dated, 17 July 2019, and it was communicated, 20th September 2000. Page 125,
This is the reason order considering your claim.
Yes, my lord. আমি ঋতুব্রত করে টাইমটা দিয়ে দেবো ডাকছে ডাকবে
So your regularization is 18,496.
Yes, madam. Yes, madam. That is 96, madam. But past service was not calculated, madam. In the similar circumstances, High Court passed.
Then why did you not challenge this reason order?
Yes, madam. I challenge the region order, file a OA application for the tribunal, madam.
Yes, 21.
Not, madam, not 21, madam. Yes.
How can you? In 21, it will be barred.
Previously, one application was filed. Kindly come to the malad. Kindly come to malad. Page malad. Page malad 117 malad. 117.
We are not asking you what happened before 17/7/2019.
Yes, madam.
After 17/7/2019, there is a time specified, limitation is specified in the Administrative Tribunals Act.
Yes.
So if you have not filed it within the limitation, can it be considered? What is the period of limitation? See section 20 and 21 of the Administrative Tribunals Act.
Tribunal application है that.
And after filing it, it is being adjourned since the last 5 years, and then you are before the
They have
court.
my lord, adjournals, all the order as annex my lord, all order as annex my lord. Well, kindly see my lord, the all order my lord, I have annex my lord, I have not paid any time my lord. My lord, court has granted time my lord from my lord 2021. My lord, the bench is not seat my lord, kindly come my lord.
No, that's all right, but see, ultimately, your claim has to be considered under the provision of the act, whether the tribunal does it or we do it. So there is no condonation of limitation, there is nothing.
Kindly allow me my lord, 1 day's time my lord, I can be privileged tomorrow my lord.
You filed an application for condonation there.
My lord, allow me my lord, 1 day's time my lord. For 1 day's time to prepare myself my lord to.
We have made affidavit of service kept on record.
18th August এ আছে। Item number 2.
Item number
Exhausting the range of hours time is to be given for the reply. If not, then within hours time it is to be filed at the statement. If not complying with that, we have to file a condemnation. The party for the tribunal.
next one also my lord, there is shortfall only for 7 months my lord, only for 7 months my lord. They have
Same order.
affidavit of service my lord kept in record.
Just not same order. Order will be different here.
Item number 3. This is my evidence.
Date of filing.
My lord, date of filing, my lord, 2025, my lord. My lord, if your lordship.
Item 2, I am appearing for that.
My lord, initially we filed a my lord OA, my lord. In that,
When you filed your?
my lord, first OA filed, my lord, 2023.
No, this arises out of the OA which has been filed on which date?
My lord, I have annexed all orders, my lord, kindly.
No, just give us the date. Where is the OA page? Where is the OA page containing the affirmation?
My lord.
April 25.
This was 24th of April 2025.
Yes, then we'll proceed. Yes.
My lord, this matters relates to my lord shortfall in qualifying service of the my lord petitioners, my lord. My lord, the first way was disposed of by direction to the respondent authorities to pass a my lord reason order. My lord, the authority my lord passed a reason order which your lordship will find at my lord page 66, my lord.
What is the date of this order?
Well,
It is 8/3/2025.
8/3/2025.
What is the reason assigned?
My lord, if your lordship kindly takes pen to the page 69 and 70, my lord, although my lord they have quoted that
What is your date of regularization?
my date of regularization is of my lord 27 of October 2009, and date of retirement is of my lord 30th of June 2019. My lord, I have served 9 years, 8 months, and 3 days. Only my lord shortfall of 3 months, 27 days.
That's all. Then you are covered by Rule 36.
Yes, my lord. My lord, if your lordship kindly takes pen to the my lord reason order also, my lord, they have admitted that I was in a temporary service since last 1991. They have considered it.
That is not relevant. For you, that is not relevant. For you, it is just an issue of condonation.
Yes.
Just
Rule
relaxation.
36, Rule 36, my lord,
Under,
6 months can be condoned, and
where is you have show us Rule 36.
36 has been quoted here, my lord, also, my lord.
Where is it? You have come with our judgment.
My lord,
You have come with our judgment. We have passed a judgment on this.
my lord, your lordship judgment, I don't have, my lord.
No, any judgment.
Well, other divisional judgment, my lord.
Yes, yes.
Nirmay Chandra Chatterjee's judgment, which my lord, state preferred an appeal, the SLP was also dismissed. My lord, I am giving a copy to my learned friend also, my lord. And thereafter also Puran Chandra Chatterjee, there are
Sir,
several judgments.
this is not the issue arising in your case.
My lord, this is also, my lord, shortfall in pension as regards to my lord, 36, my lord.
This is not, show us where the court has relied on 36 to grant the relief.
My lord. Then my lord, I am referring another judgment. No, sorry, my lord. Sorry. My lord, I am referring.
This is not,
Puran Chandra Chatterjee's judgment, my lord, which is, my lord, clearly covered in my case, my lord. My lord, kindly see. This is also division bench judgment of our Honorable High Court. My lord.
আপনাদের অর্ডারটা কত কথা বললে?
sir, you are relying on judgments which do not help you. You are relying on judgments which do not help you.
My lord,
Have you seen
my lord judgment I have not seen, my lord. I am extremely sorry.
Forget about our judgment. What does Rule 36 say? Why you are not examining? Show us Rule
My lord,
36.
36, my lord, 6 months may be condoned by the my lord, government itself. When a person is in my lord, service, then my lord, in the rule itself, my lord, they have not considered.
So why you are relying on
Well,
this?
that is-
This is for counting past service prior to regularization. This does not apply to you.
Yes,
It's only a case of
there is a
condonation.
shortfall of my lord, beyond.
So therefore, we are asking you why you are relying on
The
this.
36 is my lord, applicable in my case.
You will show us 36. Oh, DCR.
আমি বলছি কিছুতেই বইটা নিয়ে আসছিস না দে না
ইনকাম রিটায়ারমেন্ট বেনিফিট আছে?
আচ্ছা
এটা কি এইখানে তো ভুলেই দিয়েছে ফাইনাল ডিপার্টমেন্ট।
না স্যার
মানে the reason order itself speaks that
Yes. What does it speak?
that his case may be considered under Rule 22(1) of the West Bengal Service Death cum gratuity benefit to extend the pensionary benefit of minimum pension subject to concurrence of finance department. So it is lying in the finance department. The issue is not still.
21.
My lord, page 71.
It refers to some Rule 21
22(1)
of
of death cum retirement benefit. My lord, page 71.
1. What does 22(1) say?
22(1).
How 22(1) will apply?
My lord, in the reasoned order, it has been specified.
22(1) is not an issue here, sir.
Yes. The matter is,
Please, neither of you are looking at rule 36. In this case, rule 36 will apply.
but I just now received this brief.
36 will happen.
No.
আরে বইটা খুঁজে পাচ্ছি না ওখান থেকে, প্রবলেম হয়ে গেছে, আমি রুলটা আলাদা করে রেখেছি।
The matter is pending with the finance.
What pending? You will keep it pending forever.
But a given time maybe.
So, rule 36 decision. Wait. Also, after that, they are saying that they don't.
বই আনতে বললাম, বই আনতে পারি।
Let's come later.
What is the shortfall? How many days?
3 months, 27 days.
Intentions could not be.
এই বইগুলো ফালতু স্যার, খুঁজে পাওয়া যাচ্ছে না কিচ্ছু।
Oh, what will happen? See, the far is 21. Double check.
নেই নেই, চলে এলো একটা বই।
Sorry, not hold. I'm sorry. Yes, I'll do. Not hold one. Please. Just click. Page 21 deals with that one. This he will not. He will not. Suddenly he will not.
আরে দাঁড়িয়ে না পুরো বইটা আনতে পারিস। My lord, 36 my lord, in this judgment has been quoted, my lord, একবার দিন my lord,
কোন জাজমেন্ট আমাকে দেখাও না।
বললাম জিক্রিয়া। My lord, I am only referring for my lord 36. Now, authority has decided in terms of rule 22, even if rule 22 they consider, in that case also, my lord, I fall within the purview of 22, my lord.
তো আজকে চলছে না।
In this my lord case also, my lord, there has been a shortfall of 4 months, 7 days. This 36 টা দিয়েছি my lord, দিয়েছি 36।
কোনটা তো দেখা যায় রুল 36টা কোন জাজমেন্ট?
জিক্রিয়াতে আছে, বললাম জিক্রিয়া, এই যে দিচ্ছি আপনাকে, দাঁড়ান, এই নিন, এই নিন, এই নিন, এই নিন। 5 আমার কাছে ছিল, আমি খুঁজে পাচ্ছি, এতগুলো হয়ে গেছে তো। নিমাই চন্দ্র চ্যাটার্জি স্কোয়ারলি অ্যাপ্লিকেবল।
Three months, 27 days.
Any conditions you can. What is the condition which may be? That we are doing this or we are giving service for 3 months or whatever. But you are not getting the paid for the- Any other benefit will not be counted because it says the law says that efficiency should be controlled. Making of the minimum prescribed qualifying service for purpose should not be controlled for definitely or for
You have seen Rule 36.
Yes.
So you impose any condition that you want to impose.
Well, the learned tribunal has left the issue over the authority.
Yes.
Well, there is no rejection at all in the reasoned order. They have merely said that the permission of the finance department is necessary, so it is lying with them. So what I submit before your lordship, my lord, let the finance department be directed to complete the issue within a given period. My lord, this is my only submission. Because it is not rejected, against which they have come before your lordship.
Rejection. Is in order passed?
Reasoned order.
Hmm.
The last paragraph,
Is in order rejected?
they are admitting that he is entitled. They have not refused it. Still alive.
the claim in the present
What do you mean finance department concurrence? What is the concurrence required? Where is the role of finance department in 22? Show us, please.
My lord, if your lordship considers that part of the issue, my lord, in that event, my lord, lordship kindly can direct.
Not without an opportunity. We will not do that. You don't want to file, we'll do it on the next day.
No, I will
Or
definitely.
we'll record that you don't want to
No, no,
file an
my lord,
opposition.
I
Then
will
we may
definitely
proceed.
file, my lord. I was just assisting your
We
lord.
appreciate your suggestion, but the record should be straight. That you have been given an opportunity and you want to proceed, then we can proceed. And if you want to file it, then you file whatever you want. We are not averse to deciding it without an opposition. But tomorrow you will say before the higher forum that without even an opposition, order was passed.
No, that I don't, my lord. In the meantime,
So
lord,
if you want, we can proceed
No,
with the,
no,
we'll
sir.
record that you don't want to file
no,
an
no,
opposition.
no, I am not saying that. My lord, only thing is that in the meantime, let there be a liberty to.
That's why we have said
Yes.
that while filing an opposition, you also consider rule 36, both rules. Whatever is due.
No, what I was saying, my lord, that the authority, this order may not come in the way to.
Yes, this order would not come in the way.
Yes.
This service.
Item number 4 and 5.
No, I'm for the petitioner in the contempt application and respondent in the review application.
Kindly recall to that is that husband-wife matter were personally in chamber.
Fully resolved.
No.
No, Lord,
Last 2 days you said that.
yes.
Sir.
Now
But Lordship, whatever, yes,
stating the what will have been transcribed and resolved between the parties. Right, it's only with regard to the quantum of maintenance. Now, my lord, my learned friend's client sends me a letter saying that we want to reunite as well. Want to reunite, where my lord, a decree of divorce is standing, my lord, on the ground of 20 affirmed by my lord, up to my lord.
not affirmed, Lordship, because trial court did not grant divorce.
So, my lord grants divorce, my lord, on the ground of cruelty, but my lord,
But that how, that is just, that will be contrary to the order, it can't be.
absolutely. So, my lord, on the quantum they are agreeing.
That
But
they
now
can
he-
always go to the higher
Yes,
court.
no,
Yes.
that is Lordship.
Item number 6.
It is a review application. Now the hurdle is over. Because your lordship wanted a change of vakalatnama.
No, we said whether it can be filed without without an NOC
Yes,
or without the erstwhile lawyer.
it has been filed. With no objection, vakalatnama has been filed
Yes.
on 5th of August.
Which is it here?
August,
Can
serial number 72.
August को file हुआ वकालत filing number 72.
It is at serial number 72. Perhaps that is why the name has appeared.
Name of the new council has appeared.
New lord.
Serial number
vakalatnama দিয়েছি নতুন এগিয়ে এসো না বলো না নামটা সমীর কুমার ঘোষ Oh, my lord.
How can we?
Oh, yes. Under the notification, it is there. Whenever the presiding judge is there, the review application can be heard. That is how the notification has been made. Even a
No.
parted matter,
No,
even
sir.
a parted matter, my lord.
No, sir.
It
As
is
long as the other bench is, other judge is available, it has to be. If the other judge is not available by virtue of transfer or retirement, then of course the presiding judge sitting with someone else. So we will not consider. It
Therefore,
will-
unless we get the new chief justice,
list after 2 weeks. Both of us agree we can have it listed on any day. If his lordship is not sitting in any other
you
DB,
the chief justice now, the acting chief justice.
you may do so, but that's not required, sir. If his lordship is free and we both agree to constitute a bench, we'll take the chief's consent and
No,
have
the
it.
bench has to be constituted by the chief justice.
Not necessary.
Your lordship is sick. Your lordship will, according to your lordship and convenience of the judge.
His lordship, we can resume, we can assemble. That's why we are saying, let's see 2 weeks.
Yes.
If not, then ask your junior to mention, will with convenience will. And if that bench resumes, then everything is over.
Preferably, could it be done on the by 18th of this month?
List on 18th, list on 18th.
18th.
Let's see.
Sorry. I lost my privilege. Yes. The privilege.
18th also. List on 18th. The appropriate bench is not available today, it's on 18th.
Item number 7.
Number 7, I am for the respondent.
My lord, item number 7 on behalf of the Mr. Shonojit Kose, appears to the petitioner. My lord, my lord, fixed to him. In detail, my lord, my lord. I think you should pass over, my lord. PM, my lord. Hardly question, arrest will not come, my lord.
You are son of second wife,
Yes,
and the first wife has no offspring.
has no issue. And he has no objection. She approached the concerned authority.
And the first wife also has no objection.
First wife has no issue.
Whether she has any objection to your appointment,
No,
he doesn't have any objection.
does not have any.
Her
He
offspring,
approached, better he approached the concerned authority to give him appointment, to protect the family. And Malad, division bench decision has already been there.
Justice Chakravarti's decision.
Malad, the
Yes.
Railway Board Circular 92,
Huh?
which prohibited appointment of Malad second wife's son, that circular was declared ultra vires. And that judgment was upheld by the apex court.
Where is that judgment?
Hello?
Where is that judgment?
Paragraph 8, 9, 10. This is 2010 volume 3 SLR. The learned judge considered the judgment. 2010 volume 3 SLR 857. Paragraph 5, 6, 7, 8, 9.
They are relying on the same circular.
My lord, yes. On the basis of same circular, the
And where is the apex court judgment?
all the in the let's say trial court have already quoted all the judgment of the apex court.
Whatever. In the first one is the
ওটা আছে হেডশট নেই
first one, 94.
প্রতিদিন তো রাইট
State of PR. First one. Internal kids. PR party.
মুকুটে জাজমেন্ট বার করো আমি বইটা নিয়ে এসেছি ইউনিয়ন অফ ইন্ডিয়া ভার্সেস ভিআর ত্রিপাঠী ইউনিয়ন অফ ইন্ডিয়া ভার্সেস ভিআর ত্রিপাঠী এটাতেও আছে সুপ্রিম কোর্ট কেসে সেখানে এসআরটা দিয়েছে এসআরটা আমি নিয়ে আসিনি ভিআর ত্রিপাঠী ইউনিয়ন অফ ইন্ডিয়া ভার্সেস ভিআর ত্রিপাঠী
Yes.
But it was not sustainable. More with the news. Before the government was considered like Supreme Court in Mukesh Kumar, the civil defendants. Now it's already that incident. Page 40. And it's always said to it is updated by the
Yes, all is, everything is settled by judgment, so many judgments.
For judgment also.
Triparty judgment or Mukesh Kumar? Which judgment it is? We are Triparty or Mukesh Kumar?
Yes, yes.
Give us first.
Paragraph 20 and 22.
No, but we are Triparty is dealing with the earlier circular of
That 92
92, but thereafter in 2013 they have come out with.
is not applicable. Court says, you will also kindly go through paragraph 20 and Madras High Court division bench followed. Patna High Court full bench followed.
Yes, yes, we know.
Paragraph 20 and 22.
Yes, this has taken into consideration both the circular, 92 and 13 circular, both. There is nothing.
I kindly fix 2 p.m. my lord.
No, no, ask him to come. What 2 p.m.?
2 p.m. my lord. 2 p.m. my lord.
Ask him to come. We are taking it up at 12. Ask him to come.
PM we are fixed.
Alternate side.
I think we have. No, not 2 p.m. matter. Original side.
Ask him to come. Ask him. We'll take it up before we rise. Before we rise, we'll take it up.
Fine. No, may I get back the
Yes. You are filing an opposition to the condonation.
condemnation? 162 delays. There is no explanation. Merely said that
Item number 8.
Lordship, in this matter, Mr. Kolol Basu is appearing on behalf of the petitioner. Unfortunately, he is on his legs, Lordship. For that reason, I am seeking for a short passover.
Not correct. Call the next.
Item number 9.
My lord, in this matter, I am for petitioner, my lord. I am led by Mr. Vikas Ranjan Bhattacharya, my lord.
he is already engaged in a Supreme Court matter, my online, my lord.
Not today.
Not today, my lord.
Item number,
Lordship, I am for the applicant, Lordship.
যাতে কান্ট্রি দিয়ে কান্ট্রি দিয়ে নেই not today not today পনেরো নম্বরে একবারে কান্ট্রি দিয়ে আছে তো স্টেটে কান্ট্রি দিয়েছিল করেছেন কান্ট্রি দিয়ে আছে কান্ট্রি দিয়ে অ্যাপ্লাই করুন
Yes.
Then the order, Lordship order dated 10th of June 2025. Lordship tribunal order dated. I think
Yes, so what is
my petition, Lordship order, paragraph 4, Lordship.
you are relying on which? Yes.
Now, my lord, if your lordship will not kindly see the order dated 10th of June, 2025.
Tribunal's order.
Yes.
We have just gone through it.
Yes. Now, my lord, only one thing, my lord, your lordship would find. Just, my lord, I just showed to your lordship, my lord, two things. My lord, kindly straightaway comes to page 49 once.
Yes.
This is the notification. Now, my lord, your lordship, if your lordship, my lord, kindly tell me, my lord, page 51, what are the documents are required to be uploaded? My lord, just after the, my lord, box, corrigendum, your lordship would find, please note the candidate must upload photo, signature, homeopathy council registration certificate, the scanned copy of original at the time of filing of the application form. So, my lord, what I was supposed to upload, that is, my lord, photo, signature, and the homeopathy council registration certificate. These things, my lord, I was supposed to upload. Now, my lord, kindly see, my lord, now next, my lord, page 54, my lord, kindly have a kindly tense, my lord, page 54. Page 54. Now, my lord, you also find, my lord, list of the documents in two separate sets, arranged in the following order. What I have to produce, my lord, at the time of interview. Copy of the interview call letter, copy of the application form duly signed, color passport size photograph, caste certificate, disability certificate from the appropriate medical board if applicable, photo ID proof with address like passport, voter, Aadhaar, driving license, etc. Age proof certificate, the Madhyamik or equivalent admit card certificate, degree in homeopathy mark sheet certificate, homeopathy council registration certificate, house staffship certificate, and other experience certificate in homeopathy as per advertisement, if any, if the candidate, the specific mention the start date and the date required. So, my lord, I have to produce the, my lord, experience certificate, my lord, at the time of, my lord, interview, my lord, before the interview board. Now, my lord, kindly have also note, my lord, there is a note. After just note, you'll also find you may not be allowed to appear in the interview if you fail to produce the required certificate documents in the original or required eligibility criteria is not fulfilled. So, my lord, at the time of uploading, my lord, I have to upload, my lord, 3 documents. I have shown to you, lordship, my lord, page 51. And subsequently, my lord, before the interview board, my lord, I have to produce, my lord, these are the documents. Until unless, my lord, I produce these documents, my lord, I was not even allowed to participate in the interview. Now, my lord, what I have done at the time of interview, my lord, I produced my certificate. Now, my certificate, my lord, was not even considered. Your lordship, my lord, fine, my lord.
Where's your certificate?
Yes. My lord, the certificate is page 17. My lord, connect to page 79. This is a certificate dated, my lord, 8/12/2020. This is a certificate that Dr. Sukanta Saha, son of such and such, has been engaged as a part-time teacher in the Department of Physiology of this institute since 2nd June 2003. He is also working as an attending physician in OPD since the date of joining. Now, my lord, zero দিয়েছি। Now, my lord, so far as the certificate of private respondent is concerned, my lord, you will also get it, my lord, at page 81. Type copy. 80 is the, my lord, experience certificate. Type copy is at page 81. It is also, my lord, dated, my lord, 18/12/2020.
And that I am applying for response for 8 million.
Yes.
Now, my lord, only one thing, my lord, I will submit to your lordship, my lord, page 78, my RTI reply. My RTI reply given by the department, my lord, to my queries. Now, if your lordship, my lord, kindly see the, my lord, query number 3. What marks I obtained for other experience in the homeopathy form of any government institute or government affiliated organization out of 5 marks. Marks obtained by the candidate in other experience is 0.
When did you appear for the interview?
Lord, I appear for interview, my lord, on yes, my lord,
Why?
but 22nd of December 2020.
And when the final result was published?
Final result was published, my lord. Page 57, my lord. Well, that is on, my lord, 20th of December 2020.
28.
2nd November 2020. Page.
Page 57. 2012-19.
Final list, my lord, on 7th of January 2022.
Where is that?
Page 82. Page 82, my lord.
7/1/22.
Yes.
So in the interview, they did not allow you to submit the certificate.
Yes. Allowed. My lord,
Where have you stated that in your way? That they accepted the certificates?
ওই তো কোথায় বলেছিস? একটু। My lord, your lordship, page 32. Page 32, my lord, inner page 7 of the tribunal application, my lord, that is Roman 2. That after the submission of the application as per advertisement, the applicant with other candidates was called interview on 22nd of December 2020. In terms of the interview call letter, the applicant appeared before the interview board, showed his requisite documents as asked for by the authorities. Subsequently, the scorecard was uploaded in the official website of the West Bengal Recruitment Board, and whereupon your petitioner applicant came to know that this marks was allotted. Now, my lord, subsequently also, my lord, it is stated.
So there is no averment by you that this certificate of experience was accepted by them.
I produce all requisite documents. That is a, my lord, averments, my lord.
Therefore, we don't know that why after the interview you were waiting when they didn't accept. You should have at that time you should have raised this issue.
So, my lord, I applied for my RTI. RTI reply was page 78. My lord, you lost fine when the RTI reply was given. That is, my lord, given on my lord 8th of March 2022. May I just place 2 pages, my lord? If you lost, my lord, can you done page 35?
Yes.
Page 35, my lord, Roman 6. May I just place it, my lord? The applicant, Roman 6. Applicant further states that from the RTI reply dated 8/3/2022, it appears that your authorities has not given any mark to the applicant in the head of other experience. In the recruitment notification, particularly in column 3, the said notification, there is a clear indication of the respondent that other experience of the candidate should be clinical, teaching, research, and other
No,
experience.
we
in the
just want that averment that on the date of interview, they have accepted this certificate.
My averment is there to the effect, my lord, page 37, my lord, just said, page 37, paragraph, subparagraph 8.
Yes.
Your applicant states that under which the method 5 marks has been allotted to Mukunda Mondol. Under the same method, the applicant is also entitled to get 5 marks, being similarly circumstanced. Now, this averment I have made. Being similarly, my lord, your lordship, my lord, kindly consider one thing. At the time of
You are not similarly situated. You are not similarly situated.
I uploaded my
The person with whom you are claiming parity has given a certificate of 2019.
no, my lord.
Yes, sir.
2019 as well as he is in the I have annexed 2020.
No, you may
certificate.
have annexed.
Yes.
We don't know how you have got it. You
Now,
may have annexed, but he has submitted a certificate of 2019. And if he has been given wrongly, should you be given wrongly? Then that question will arise.
That is the thing, negative equality.
He has given in 19. They have filed an opposition. They have annexed his application of 2019, showing that it was uploaded on the website, not hard copy certificate. There is no question of parity. Therefore, we asked whether they accepted. If they had accepted, you had a cause to wait till the result. If they have not accepted, if you don't say they accepted, why you waited for the result? So if you would have emerged successful without the certificate, it was all right. Then if you have not emerged successful in January, in March, you file an RTI and you file an OA. Now, whether in this way it is to be looked into.
So far as certificate is concerned, my learned friend also annexed 2015 certificate also. Now, kindly have a look.
You may annex everything here.
No,
That
my-
basic averment is lacking, that on the date of interview, they accepted the certificate. That's lacking.
So far as this certificate is concerned, if you lordship, kindly again, I don't want to repeat it, the uploading was not at all necessary.
No, that you have
Uploading
already
was
said.
not at all necessary.
That you have already
Yes,
said. So
yes.
maybe you thought it was not necessary because there was not a specific mention.
Yes.
The clause requiring uploading was limited to 2 documents.
2-3 documents.
But when they didn't accept it at the time of interview, you could have turned around and said that there is no clear instruction why you are not accepting today.
This is not my case. They have accepted the certificate, but marks was not.
We are yet to find that averment that the certificate was given and accepted by the authorities. Still, they have not taken into consideration or not given me the benefit of that. Because that certificate is after your date of the last date of application.
Yes, 7th.
So how it can be accepted? You know the law is settled. All the qualifications have to be fulfilled as on the last date of submission of application. Therefore, these are the difficulties. That's why we are saying
7th. My lord.
Unless you are required, why you should argue, sir? If you are required, we'll ask you. If there is something which requires your reply, we will ask you.
Now, my lord, so far as certificate, my lord, annexed by my learned friend, my lord, kindly have a look, my lord, page 15 of the
We
opposition.
have seen it. Come
Oh,
to
tell me.
annexure R by 3 of the opposition.
Yes, yes.
Come to
Now, my
R
lord,
by 3 of the
R
opposition.
by 3. I am also R by 3.
Yes.
Now, my lord, kindly see, my lord, this certificate is saying, this is, my lord, memo number 604 SGP 2018-19 dated 15/11/19.
19 years.
15/11/19. It was, my lord, signed on, my lord, 18/11/19. At the left hand side, my lord, kindly have a look.
Maybe.
Secretary in charge.
So how it is invalid?
Kindly consider also this fact. How
That's
this
the legitimacy of this certificate is not an
this
issue here.
certificate is dated 15/11, signed on it
Signed after 3 days.
after 3 days.
So there is no issue of legitimacy of the certificate.
Memo is dated, my lord, 15/11/2019.
These submissions are devoid of any substance because that's not an issue.
And my lord, the next page, page 16, my lord, it speaks about, my lord, Hoibati medical officer part time in my Gram Panchayat. Now, this certificate was issued on 18/12/2020. Page 16. Page 15 is certificate dated 15/11/2019 and page 20 is certificate dated 18/12/2020. Now, which certificate had been taken into consideration by the state, I do not know. There is no report coming from the state. Which certificate had been taken into consideration by the state? We don't.
It's in the opposition.
But the state has not filed any opposition. There is opposition by the private respondent. Let the state file a report at least. Which certificate had been taken into consideration? I don't know, my lord.
The point is your case, whether it is made out or not. We accept that his has been accepted. It's not your case that it was accepted. It is not your case that it was.
Well, my problem is
He will not.
no, my problem. I am claiming for no. What I am claiming for parity. Now, your lordship may say that negative equality I cannot claim.
No, it provided you could have said that yes, my certificate also was accepted, but they are not given marks. This is not your case in the OA. We went through it, then we asked you. Maybe we have missed. You have also not pointed out.
That is a statement.
Because then this conduct can be considered to be a normal conduct. That I went, I gave it, they accepted it. I had no option to. At that point of time, there was no doubt in my mind. When the result came, then I was wondering that how I have got a lesser mark. Then I came to know that they are not accounted for this certificate. It's not your case.
May I come tomorrow, Lord? Only not today. Day after tomorrow. Tomorrow I have.
Item number 11.
Lordship, in this matter, I am appearing on behalf of the petitioner.
Chip, reaffirm করার অর্থ ছিল না। Lordship, তার আগে বলে একটা ছিল। Lordship, Lordship, there was an chip, Lordship, Lordship, the affidavit in opposition will have to be reaffirmed, Lordship. I find there's an order to that effect, Lordship, but I will seek time for. Oh, that's the conclusion for.
Why higher rate? Tell us.
Lordship,
Why higher rate of interest? On what basis? Just tell us. Your claim is founded on some provision, some rule. What is your claim is founded on what?
Lordship, my only contention is that at the time when the interest was disbursed to us,
When it was disbursed? When it became due and when it was paid?
Lordship, the petitioner died in the year 2008. The person who was working, the present petitioner is his wife. Now,
So the employee died in 2008.
yes, the
What is the
gratuity
date of demise?
Lordship,
Anyway, so the wife is
2008.
before us. The wife is before
Yes.
us. And she got the dues on in which year?
2021, I believe.
21.
21. Now, Lordship,
So they have given a interest of 5% on the dues.
yes,
You say 18.
yes, Lord.
Why? That's what we are asking.
Lordship, my contention is that the interest rate should be according to the RBI fixed deposit rate at that point of
So where is this law that interest has to be as per the fixed deposit rate? And which fixed deposit gives 18%? Tell us.
Lordship, the 18%
We
is
would
not
be glad to know.
the 18% is not stated there, but Lordship, the 5% which was provided.
Where is the scope for a tribunal or a writ court to go into the quantum of interest? And who prevents you from raising this issue in an appropriate civil proceeding? Who prevents you? How it can be looked into by the tribunal or the writ court or the tribunal will be guided by any rule or provision which mandates payment of interest.
Lordship,
Since they have paid 5%, we presume that there must be some provision in the Gratuity Payment Act or somewhere, wherever. They must have relied on that.
I understand.
So why, if you say 18, why not 25? Why not 15?
Lordship,
So where do we peg this amount? And what is the basis for this determination? And can it be done in a writ proceeding or in a judicial review?
Lordship, on the last occasion, I have placed a judgment of Honorable Justice Indira Banerjee, but unfortunately, I have only one copy.
Give us, let us.
I tender my apologies, Lordship. This is my copy. So there are some markings. Lordship, watch.
So there is no law decided that 10% has to be given or 15% has to be given.
Payment of gratuity should be given 5%.
Yes, what is the justification for paying after so many years? Before the tribunal, an opposition was filed. Yes.
But the opposition has been reaffirmed, but it has not been, that is what I was seeking time, Lordship. The opposition has to be reaffirmed because I don't think it's in Lordship. What my learned friend will have to give me a copy. Copies have not come. Copy. So and that Lordship will kindly keep it after a fortnight.
Where is the gratuity payment order?
Lordship may kindly takes up page 81 of the
51.
81.
The last page is 79. There was some dispute regarding apportionment of the dues. There was some dispute regarding apportioning of the dues between beneficiaries.
Some was disbursed earlier, late.
To get the shares. Apportionment.
Yes, Lordship, that was to be divided between the wife and the son. Both.
Why? Why it was required to be divided? Why not paid to the wife altogether?
Lordship, at the first instance, it was paid part by part to the wife and the son, I believe.
At the first instance means when?
Mother. Yeah. Mother. The mother is the direct. But why in 2020 they have restricted yes, certificate? Ever.
Very time.
Their religious ever. Paragraph 12, January 22.
What have you stated in paragraph 16?
Lordship, Lordship, in paragraph number 16, we have stated that when the final pension amount was received, it was given to both the, it was divided between the wife.
Read.
It's pertinent to mention herein that a supplementary affidavit was also filed on behalf of the petitioner in the above mentioned application, wherein the fact of the receipt of a final pension payment of rupees 6 lakhs, that is rupees 3 lakhs each, into the bank accounts of the petitioners, but the interest was not paid by the concerned authorities, which sums up.
Sums up to rupees 10,35,228 according to you,
Yes.
as per
As per-
fixed depository.
Yes.
Yes.
Calculated in regards to the Reserve Bank of India rules was brought on record. The petitioners state that an amount of rupees 4,68,353 had been already paid by the respondent authorities to the petitioners, and an amount of rupees 5,68,353 as interest at the rate of 5% for the delayed payment of gratuity.
So many different figures, which one means what, it is difficult to understand.
If
First you say 3 lakhs each, and then you say amount of 468,353 has been paid. So which amount has been paid?
if Lordship may kindly comes to the paragraph number 17,
Yes.
Lordship, the fourth line, wherein the learned tribunal was pleased to observe that the amount of rupees 5,68,353 as interest at the rate of 5% for the delayed payment of gratuity had already been released by the respondent authorities, and the learned tribunal was not satisfied with the contentions of the petitioner that they are liable to receive an interest. Lordship, that was the total amount which was after 5% of the 5% was provided.
No, what is this figure of 468,353 in paragraph 16?
Lordship, this is the amount.
You are saying 3 lakh each was paid. 568,353 is paid as the interest component. But what is it? 468,353.
Lordship, the 5 lakhs which was paid, that was the interest of 5%. Lordship, we have our contention is that we were to receive more. That is the 10,35,228.
Again, we are asking you, what is this amount of 468,353 in paragraph 16?
This is the amount which has been paid, the delayed interest amount.
Then what is 568,353?
That is the amount we expected that we should receive. For that reason, according to the interest rate, that is the
It is not clear what you are trying to say. The petitioner state that an amount of 468,353 has already been paid by the respondent authorities.
yes.
And an amount of 568 as interest at the rate of 5% on the delayed payment of gratuity. What does that mean? Now, when you read paragraph 17, it says,
Wherein
the learned tribunal was pleased to observe that an amount of 568,353 at the rate of 5% had already been released by the authorities. What is the significance of these two amounts, 468,353 and 568,353? According to you, that 5% interest has been paid.
Yes. The total amount along with the 5% interest has been paid to us. Now our contention is, Lordship, that it shouldn't be 5%, it should be more than 5%. If Lordship may takes up paragraph number 19 in our submission, the last line, Lordship, as the petitioner's father expired in the year 2008 and the prevailing rate of interest was 8.25.
If that is his case, not with the concern of some of the satisfied.
Does not make sense because where is this?
Yes, if this is the so
So this has been also paid, and this has been also paid, and this has been also paid.
just that of satisfied. Take it that way. Then that given as for
He's saying this is the total due, out of which one of these components are. Yes.
Chief, my submission is that when the
5% has been paid to you.
you can make it.
Has to be paid to the calculation chart, showing the details of calculation. Yes, so there is no dispute that there is a delay. You have paid the interest, only the quantum is in dispute. We'll just say that whatever is the due on a fixed deposit over this period, according to that rate, they will calculate. And if any arrears occurs,
If there are any.
along with a calculation chart showing the details of calculation. If
Just for clear whatever.
Item number 12.
Only logical. Grateful. When we are not certain. Unless we say compound.
Well, I'm for the state respondent in this matter, my lord.
I am appearing for the petitioner, your lordship. My learned senior is unable to come due to hospitalization of a relative. I am praying for not this week, my lord.
In that circumstance, my lord, I am praying for adjournment 2 weeks time because my lord, I have to take instruction from the department concerned, my lord. Kindly adjourn the matter for 2 weeks, my lord.
Lord, I beg to appear for the petition, my lord. But I'm led by Mr. Hussain, my lord. I'm for a week's adjournment, my lord.
Why, sir?
But he's not present in court, my lord. He will not be available for this week, my lord. A week's
As
adjournment.
prayed list after 2 weeks.
Deep privilege, dear lordship.
What do you want?
No, Lordship, please take.
আমাদের তো দেওয়া আছে।
একটা না বাজে
Call it.
Item number 7.
But I am grateful to Lordship that Lordship had given opportunity me to place my case. আপনার কি স্যার সেকশন 5 অবজেকশন আছে?
Yes, how when this circular has already been,
অবজেকশন আছে?
when the circular is already considered by so many division benches, by the Supreme Court, again, how you're raising this?
Yes, my lord, that
That triparty judgment is
yes.
there, that there is another judgment of the Supreme Court, our division bench, Madras High Court. You are litigating in every court.
and my lord, the railway also relied my lord the division bench judgment also in the on the same point, my lord. Anyhow, my lord,
That is one judgment in between, we have seen it.
yes,
How that improves your case when the Supreme Court has affirmed the view in Triparti's case, then how you can rely on a
and
division
my
bench?
lord, another point is this, my lord, each and every railway board circular, according to the Railway Boards Act, that has, my lord, the statutory force.
Maybe the Supreme Court says it is not enforceable. Then where is the question of statutory or non-statutory? It cannot rise above that.
Definitely not.
So therefore,
My humble and respectful submission, my lord, that point was not considered by those honorable court's judgment, my lord.
so we will review the Supreme Court judgment.
My lord,
Any way you submit, no case is made out. We will not review. So that is binding us on us as much as you. We have to go by
and my
that.
lord, I shall not take more time, my lord. The gist of the facts is there, my lord, that the person, my lord, was the railway, my lord, RPF employee. And my lord, the second marriage was solemnized, my lord, and that was suppressed.
Who is disputing this? Who has disputed that you are required to give us this background, that his son of second wife, marriage took place since during subsistence of the first marriage? Who is
And-
disputing?
Yes, my lord. Another thing, kindly consider. my lord,
Point is, can he be barred from a consideration? That's the only thing. That is now settled
and
by.
my lord, according to the
writ petitioner, that is the first wife of the, my lord, the deceased railway employee. In the second marriage, out of the second marriage, 2 sons and 2 daughters. My lord, kindly consider what is the, my lord, the principle behind the compassionate appointment, my lord.
That is not your case. Your case is that the circular bars consideration. There is no issue of whether he is eligible, ineligible. There is they are living in penury. Those issues are not arising. Because say this circular bars consideration. That is all. There is nothing more to it.
Because, my lord,
Once he crosses that hurdle, then comes the issue whether he is eligible or not.
at that point, my lord, the railway official, my lord, rejected their prayer on the basis of the railway board circular.
That's all.
So those points, my lord, there was no opportunity to consider
He
this.
is arguing those points. Again, that is not relevant. Nobody is saying that because the circular does not apply, he must get. The Honorable Single Judge has also not said that he must get. We have seen the order. It is subject to consideration of his eligibility.
The other condition.
Subject to fulfillment of the conditions.
And my lord, kindly consider that 2 judgment, my lord.
So relying on the Lipsing judgment.
My lord, yes. That is, my lord, Union of India versus Basanti Devi. That is also the division bench judgment, my lord.
This will override the Supreme Court judgment. Is that your submission?
No, my lord, definitely not. My
You are unnecessarily giving all this.
My lord,
All you have to say is after the Supreme Court judgment, can you impose such a bar? That's all. Forget about this division bench and our division bench and Madras High Court.
that division bench judgment, my lord, on the same point, considering that the railway board
So
circular.
therefore, we should look into it and ignore the Supreme Court judgment. We'll record your submission. Should we record that submission? That the party judgment should not be looked into by the court, and the other judgment arising from Madras High Court should not be looked into, and the railway should be permitted to rely on the decision of this division bench. What kind of submission you make? Have some substance in what you are submitting. You are not just here to say whatever they tell you to say, that show this judgment. Why you are showing this judgment? What is the law of binding precedent? Which judgment is to prevail? You address us on that. Tell us how we can consider this in the face of VR Tripathi. Now make your submission.
Because, my lord, that is on the same point, my lord, that considering the railway board circular. But, my lord, that Supreme Court judgment, that is, my lord, the substantial question of law that was decided. My lord, that the second wife son, my lord, is also.
You are wrong, sir, factually. Factually, you are wrong. Look at the judgment of VR Tripathi. It says 92 judgment, 92 circular and 13 circular. Both are ultra vires. It does not only deal with the substantial issue of law arising from section 16 of the Hindu Marriage Act or article 14. Please read the judgment. Get your facts clear, then make your submission.
And, my lord, one point, kindly consider that.
So every time we say something about your submission.
No, only one point, kindly recorded that the according to the Railway Board Act, my lord, that has a statutory force, my lord, only that one.
For what? So what is your submission? Tell us that the Supreme Court judgment does not apply.
My lord, kindly see that the Railway Board circular says that the second marriage sons, my lord, or my lord daughter, they are not entitled for.
Pointless submissions you are making.
Okay.
Repeat. So if you want to indulge in luxurious litigation, we'll consider every submission.
My lord,
Make
my
your
only
submission.
submission is that in the.
No, make all your submissions. So which judgments you are trying to. You are railways, you can indulge in this luxurious litigation. We cannot stop you.
My lord, paragraph 1, 2 and 12 to 16, my lord.
Yes. Mind you, it will entail consequences. We are being very clear. Yes.
My lord, these.
We know that you are contesting at the cost of the government of India, but then it will entail consequences.
My lord, for this reason, my lord.
You are a state with the meaning of Article 12. You are arguing a case contrary to two judgments of the Supreme Court and saying that it has statutory force, as if it brings it above the judgment of the Supreme Court.
My lord, I am, my lord, only submitted, kindly record my submission. This is because.
Why? For what?
My lord, only, my lord, because, my lord, in the Supreme Court judgment, that the railway board acts was not considered. For this reason only, my lord.
So what do you want to argue before this forum? What should we say about the Supreme Court judgment? That we are asking you. We want to record that the railway has taken a stand about the Supreme Court judgment, relying on this provision to say what? What do you want to say? What is the point you are trying to make?
My lord, my only submission is this: in the Supreme Court judgment, which was relied in the impugned judgment, my lord, in that Supreme
What
Court.
the Supreme Court judgment says, please read it first before you make your submission. Please read it. Where is the judgment? Making submissions in air. You are not even come with the judgment and you are making such unique submissions. They gave you time for more than an hour. You know that he must be knowing that this judgment has been read. This, we don't appreciate this kind of assistance. We are not here just to record your submissions. You are here to assist us and make some sense out of the situation. You are saying judgment has not considered, judgment has set aside both those circulars, whether it is statutory, non-statutory, what difference it makes? Where is the judgment? Read it. Read the second last paragraph of that.
This one, that has been started.
Where is it? Show us. You are not just mouthpiece of your instructing counsel or your client. When you are representing a state within the meaning of Article 12, it's not a private litigation.
This one at paragraph.
What does it say about both the
Paragraph
circulars?
22 that has been set aside.
What then? Then what is your submission? Now tell us. It is statutory. The set aside circular has statutory force. Is that your submission? Yes, 92 and 13 both are ultra virus. So now we should record that it is statutory after the Supreme Court has set aside. What kind of submission? That even he could have said, we waited for you. We thought that you will take a stand which can be sustained by any standard of law. Without looking into the judgment, you are making a submission. You don't appreciate such kind of a submission. You are bound by that judgment just as much as we are bound. You are bound, whether it is statutory or whatever. What difference it makes? That statutory circular has been set aside. Which circular has been set aside? The one which you are trying to say is statutory. So what good is it? Give the judgment, please. ये दीजिए
প্রিন্ট আউট দিয়েছে ওনাকে প্রিন্ট আউট হয়ে গেছে প্রিন্ট আউট হয়ে গেছে এই যে এই যে। নমিতা গুপ্তা এটা পাশে Yes, we'll pass the order after. There is a section 5 application, we are allowing it.
Section 5, 162 days delay, and there is no proper explanation.
During your application for conduct.
Yes. My lord, that order was passed on, my lord, the 4th of December 2024.
Can one of 2020.
And my lord, the certified copy was applied on my
Order was passed on
4/12/2024, my lord. And then, my lord, the certified copy was
For a
applied
moment, kindly,
yes.
on 7th of February 2025.
Certified copy was applied for.
And my lord, the authority decided to file the appeal on 5th of March. And my lord, thereafter instructed upon the learned advocate and engaged them, my lord, on 12th of March. And my lord, thereafter, my lord, the draft was prepared on 24th of April 2025. And my lord, the appeal was filed on 15th of May 2025.
Right, the certified copy was applied. No, made available.
Yes, my lord, 5th of 2025. So 7th of February 2025.
That was application. 7th
And my lord,
application.
this is also after 30 days, my lord. Certified copy was applied after 30 days. So that relaxation of 30.
Not 166, the stamp report is less. 93 days.
According to my lord, the 164 days. My lord.
93 days.
150. What was it?
93 days.
93.
93 days.
Yes. 93. Yes. Where is the impugned order declining the benefit? Relying on which circular? 13th circular? No, Calcutta allowed the application. Honorable Supreme Court, out. Page 20. No, no. Page 81. Yes. You lost over. This is the final rejection by the authority.
rejection was impugned before the tribunal.
My lord, page 43, my lord, of my stay application.
This is a general. Yes, sir. Counsel. Does it clarify the area? Unless the administration has permitted second marriage. This is the final order.
Yes,
19 March 23.
yes, 19 March 2020, 2013.
The final order.
19 months.
19 March 23. Order final.
Final, sir.
Ulta.
19.
The Malad, the circular was, Malad,
Final order কত তারিখে ছিল? Final order টা
PC page 43.
43, 43.
Same thing was produced. 82. Same thing produced.
they have considered in terms of relevant letter dated 2nd January 1992.
Last paragraph.
Last batch.
In view of the above, the competent authority DAR has regretted your request for consideration of appointment in favor of the above named being not coming under the purview of extant rule. This circular was second paragraph. In terms of the relevant circular dated 2nd January 1992, which was declared ultra vires by the division bench of this honorable court.
This is the last order by the authority.
Yes, yes.
We are chasing in appeal also. Please put it to. This case showing
Matter item number 1. This is my application before you go. Yes. This is pertaining to
Yes, your lordship, the bread bit of it. Now, my main point is that this person was held guilty of the charges in the departmental proceeding. Now, when he was held guilty of the charges, we are governed by, in this case, by the bipartite agreements of the bank. Now, it has different connotations than the general principles. Now, here, when a person is, if your lordships have noticed that there was a departmental charge sheet and there was also a criminal charge sheet. Now, when a person is put on trial, the departmental proceeding should have been stayed. I'll show your lordships that. It was not stayed. So that chapter is over. Now, he was held guilty of the charges. After that, he had, in the departmental proceeding, after that, he preferred an appeal. Now, that appeal was kept pending for over 10 years. They didn't do anything. Now, after my acquittal from service, in the criminal proceeding, they didn't do anything again. Now, after that, I came up before this court, and the court ordered that you dispose of the appeal. Now, if your lordships have, I'll take your lordships through the appellate order. Once you're acquitted from the charges in the criminal proceeding, then the order of dismissal without notice cannot stand.
It's without notice.
Yes, dismissal without notice.
But
is
you
the
said
order.
charge memo was issued?
The
charge memo was issued on 30th January 1996.
Yes, after that,
So there is a charge memo.
No, after that, it reached its natural conclusion. I was found guilty of the charges in the department.
So it's not without notice. It's not dismissal without notice.
The order is dismissal without notice.
So whatever it is,
Yes.
it is after during departmental
proceeding.
So it is not merely on the factum of charge sheet being given in a criminal case or any such reason.
No.
Yes.
Now, no, there is a sea change. If I am acquitted, that's what they say in the bipartite agreement, that if I am acquitted, the wording is very clear. If I am acquitted then there will be some other provision, but not a dismissal. I'll take your lordships through that. Now, in that, the
What is
appellate
the
order,
date of dismissal?
the date of dismissal, my lord, is 25/3/1999.
So 11 years before your acquittal.
Yes. But the appeal was pending.
So what?
Appeal was pending.
Yes.
And that is a statutory appeal.
Maybe.
Yes. So if I am not guilty in the criminal case, then the bipartite agreement shows that there will be something else, not a dismissal.
No, but how, once the dismissal is a fait accompli, where is the question of looking into this? Dismissal precedes your acquittal by 11 years. It's not as if the dismissal is to follow or come after the acquittal that we will apply that once you have been acquitted, there will be a different consequence. This is a prior incident. Dismissal is much prior to the acquittal.
Millard, as I've said, Millard, an appeal is a statutory appeal.
Yes.
The proceedings are still pending.
Yes.
So therefore, if it proceeds, it does not mean that my appeal is given up.
All right. Very well.
Otherwise, Millard, a dismissal here, then I have no right of appeal.
The only
that,
point,
therefore,
the only
if I am even dismissed 11,
whatever your bipartite settlement says,
yes,
it is enforceable under Section 18 of the Industrial Disputes Act. But the
Millard,
point
this is not an industrial dispute.
No, we are not saying that. We are saying it's enforceable. The bipartite settlement is enforceable, whatever it is.
Yes.
The issue now remains is there is a charge, same set of charge, which gives rise to a departmental proceeding and a criminal trial.
Yes.
In the criminal trial, you have been convicted. In the departmental proceeding, you have been, in the criminal trial, you have been acquitted.
Yes.
And in the departmental proceeding, you have been held guilty.
Yes.
So what will be the effect of this acquittal? That is all.
I'll take your lordships through that.
That's all.
That's absolutely the case.
Yes.
Nothing else.
Nothing else.
Nothing else. Now, if your lordship kindly goes through this, arrecta copy diye de. This is C, clause C. Article. Millard, may I hand over this? Xerox copy? Six, If he be acquitted, it shall be open to the management to proceed against him under the provisions set out below in clauses 11 and 12 infra relating to discharge. However, in the event of the management deciding after inquiry not to continue him in service, he shall be liable only for termination of service with 3 months' pay and allowances in lieu of notice. And he shall be deemed to have been on duty during the period of suspension, if any, and shall be entitled to full pay and allowances minus such subsistence allowance as he has drawn, and to all other privileges for the period of suspension, provided that if he be acquitted by being given the benefit of doubt, he may be paid such portion of such pay and allowances as the management may deem proper, and the period of his absence shall not be treated as period spent on duty.
Very well. Yes.
Look, I think your lordship has got it. I think the next one, I don't know whether if I may give this.
Yes, you have not given a copy of the entire.
Yes, yes, I'm handing it over. I'm sorry. So that is the case. Now, if your lordship kindly comes to the appellate order once. It's at page
So with reference to this clause 3C of the bipartite settlement,
Yeah.
what is your submission?
Yes, that means after, before I make the submission, Your Lordship kindly reads the appellate order.
No, let's go one by one. You have cited this settlement.
Yes.
You are relying on 3C to what is the submission? What is the submission based on 3C?
Submission is that there can't be a dismissal without notice because I am entitled to full pay and allowances, and I'm to be treated as on duty.
Yes.
And if Your Lordship notices, one thing if Your Lordship notices,
Yes.
in that, as I've said, the cart was put before the horse, that during the trial, it was not stayed. Now, what is there? That the clause says that then they can proceed. Now, the procedure has already, there's been a precedent.
Yes.
Preceded. So this next can't be got into. The next stage can't be gone into because the disciplinary proceeding had already taken place. If Your Lordship kindly reads that clause.
No, we have read, therefore we are asking you
Yes.
what is your submission?
So,
Yes.
therefore, an illegality is apparent on the face of the record. And this is binding on the bank as well as the employee.
Very well.
Now, if Your Lordship kindly comes to the appellate order, page 92. Now, if Your Lordship kindly see 93, page 93. Grounds of appeal. Now, this is what has been said. He was suspended from service on 10/11/1994, and an FIR was lodged by bank on the basis of which PS Bongaon registered the case with a number 35 dated 19/3/1995. In the said criminal case, charge sheet was filed on 19/3/1999 under section 420, 468, 467, 471, 409 of IPC. And after the trial, acquittal order dated 25/2/2010 was issued by the learned Judge of Special Court, Barasat. He was dismissed from service on 25/3/1999 when the trial in the criminal case had begun. Now, after this, if Your Lordship sees, so therefore, as soon as this is noticed, the order here at page 95, if Your Lordship sees, 95/5, page 95, clause 5. The penalty of dismissal without notice imposed by the disciplinary authority on 25/3/1999 was in terms of clause 19(6)A bipartite settlement dated 19/10/1996 and was based on proven charges in the inquiry, and thus the contention of Shri Nitto Ranjan Mullik Vide is undated letter that the order of his dismissal by the DA is illegal on the grounds of clause 19(3)C and 19(4) is not tenable. And then he says, from the above, it is to inform Shri Mullik that no additional relevant documents were produced. However, and he says he does not, there is no merit in the contention raised at page 96. does not warrant any modification. Now, this had to be modified. In view of what I have shown your lordships. And now, my lord, what I will be further submitting before your lordship is that this is not the general principle where one says that the evidence in the departmental proceeding and the evidence in the criminal trial are different. That is not the case, because the bipartite agreement is something different. It says that if you are acquitted, then you are to be treated as on duty, you are to be given full pay and allowances for the period of suspension. That is what it says. And that this acquittal was an acquittal, if your lordship sees, and I'll soon be citing, my lord, before your lordships, the judgments of the Supreme Court on this issue. Now, if your lordship kindly comes to the order of acquittal passed by the special learned judge. If your lordship, the court of number pata?
No, the language in which the order of acquittal is couched or employed by the court, it doesn't matter.
Yeah.
In view of the submission that
On the merits.
in view of the submission that you are making,
Yes.
that hardly makes a difference. You say there is an acquittal, give me full pay and back wages,
Yes.
treat me as insult.
Yes, that's
all.
what it says.
So therefore, that need not, for this submission, we need not go into the.
Suppose they come up and say, no, it was on the benefit of doubt. That's why I wanted to take your lordship.
Where does the bipartite settlement say that it has to be an honorable acquittal?
It doesn't.
It doesn't.
It doesn't.
So if your submission is accepted, then the language of the tribunal, the trial court hardly makes any.
Because of this Ramlal and after that Maharana Pratap Singh.
No, those are on different things.
On general principle.
Those are
On
general, you say you're not pressing the general principles.
No, it can't be. It can't be.
According to you.
Yes,
So
because of the bipartite.
according to you. So
Because of the
therefore,
bipartite. That's my main
so
contention.
if that is your case, then that need not be seen.
Yes,
The only thing is that the consequence which you contemplate, according to you, under
Yes.
3C.
And one more thing, if your lordship sees, why I told your lordship this, your lordships read 4 of that, clause 4 of that.
Yes, we have read it.
4 at the, if he's put on trial, it should be stayed. It was not stayed. Anyway,
That you cannot submit.
that we can't say after 10
Submit.
years.
It's not open to you to submit.
No, after 10 years, I can't say it.
Not say that now.
Yes. But that is my main contention before your lordship.
Yes. Yes.
In this case,
It's only the interpretation of the bipartite settlement. If it has that meaning which is being canvassed by the appellant, then he has a case. If it is not, he has no case.
it is mentioned in acquitted, but lordship, before that lordship, or 10 years back, lordship, entire disciplinary proceedings has been completed with fullest opportunity to the delinquent lordship. And there is 92 exhibits of the management. Therefore, lordship, kindly see the order of the appellate authority lordship. It's clearly mentioned. The paragraph number 2 lordship. Kindly see page 95 lordship. Second paragraph. Accordingly, the inquiry commenced on 7th March 1996 and concluded on 9th February 1998. In all, 36 number of hearings were held, lordship. Not a one-day lordship, it was held. 36 hearing, lordship. During which PO adduced 92 numbers of management exhibits, along with presenting 6 numbers of management witnesses, whereas CSF and DR submitted 4 number of different exhibitors, lordship. And lordship, after this, lordship, in disciplinary person, there is no violation, no whatever may be, lordship. And that was concluded, lordship, on 25th March 1999. Thereafter, the delinquent is totally silent. When the order comes from the criminal court, lordship, that is benefit or acquittal, lordship, then he preferred an appeal, lordship. Lordship will find page. Lordship will find
one. I don't want to interrupt, but this is absolutely not the case. I had preferred an appeal.
You will get
within
your
1
chance. You will get your chance. Please don't do this. Yes.
Lordship, kindly see page 73, lordship.
Yes. Page
73.
Yes.
In the top, lordship.
Yes.
Date is 1/10/2010, lordship. This appeal was preferred after acquittal from the criminal case, lordship. And lordship, from 99, Lordship, the present appellant, Lordship, still silent. He never challenged before the court of law, Lordship, against his disciplinary proceedings. He's totally silent, Lordship. He's a fence sitter, Lordship. When the order comes from this criminal court, Lordship, that is benefit of doubt, Lordship, then, Lordship, he preferred this appeal, Lordship, which is appearing in page 73, Lordship. And that was disposed of by the order of the appellate authority, Lordship, on 16 February 2024, page 92, Lordship. And if your Lordship and all the charges are proved, Lordship. Your Lordship already read about the Lordships. The very much judgment of criminal proceedings and departmental proceedings are to the separate and distinct. And I have already, Lordship, shown the judgment, Lordship, before the trial court, Lordship. In the disciplinary proceedings, Lordship, the sophisticated rule of evidence, Lordship, strictly does not follow. There are evidences separate in the departmental proceeding and the criminal case, Lordship. Witnesses are different, Lordship. And the disciplinary proceeding already, Lordship, concluded, Lordship, before 12 years ago, Lordship. And he never filed any writ petition before this honorable court, Lordship. After acquittal from the criminal case, Lordship, then he preferred the writ petition before this honorable court, Lordship. It's totally kept silent, Lordship.
Yes.
And Lordship, Lordship, what my learned senior friend shows, Lordship. If he acquitted, Lordship, yes, Lordship, the disciplinary proceeding has already been initiated prior to that, Lordship. And final order was already been passed 12 years ago, Lordship. And if the disciplinary proceedings,
What would be the consequence if the dismissal order was not passed prior to the conviction?
Lordship, if the dismissal order is not passed, Lordship, then there may be Lordship, some interpretation is there, Lordship, because that is pending. But in this matter, Lordship, 12 years ago, the disciplinary proceeding already been concluded. Final order has already been passed, Lordship. He never challenged before any court of law, Lordship. And there is, Lordship, already fullest opportunity was given to the delinquent, Lordship. Defense representative appeared. 92 exhibitors, Lordship. There is no scope for Lordship interference, or my humble submission. Because the clause, Lordship, if we acquitted, Lordship, if the proceeding is pending, Lordship, it may be, Lordship, there will be interference. But Lord, 12 years ago, Lordship. And Lordship, prior to that clause B also there, if he be convicted. Clause B, Lordship, also there. If he be
No, that is
not different thing, Lordship.
that is a different circumstance. We are not concerned with that.
Lordship. But in this case, also already, Lordship, 12 years ago, Lordship, final order was passed. So, Lordship, this clause is not applicable in this case, Lordship. Because in nowhere, Lordship, it is mentioned in the clause that disciplinary proceeding is pending, then the criminal proceeding, he will be acquitted, Lordship.
Yes.
There is no interpretation in that, Lordship. Way, Lordship.
Milord, in my reply, Milord, if your Lordship kindly comes to page 92 once.
Lordship, may I, Lordship, hand over, Lordship, judgment of criminal case?
He's been waxing eloquent on this
Judgment of
about 12 years. Let's settle this matter once.
Judgment on what point? You are citing judgment on what point?
Lordship, if he is acquitted, Lordship, there is no disciplinary proceeding does not, Lordship. There is no interference, Lordship. This is honorable apex court judgment, Lordship. Kindly consider, Lordship. I have also referred to the landed bench also.
If he is acquitted,
Lordship, paragraph 22, Lordship.
what this judgment is in support of what submission?
Submission that if he is acquitted, Lordship, there is no interference in the disciplinary proceedings.
No, he is not on that. He is not on the general principles. He has not even argued that. He only says that this term, this clause in the bipartite settlement is to be given effect. The moment acquittal has occurred, I am required to be entitled to full pay and allowances, treating me as in service. That is all. He is not saying anything else.
That is a submission, Lordship. There is no interpretation.
Therefore, that is a limited submission. You need not labor with all these general propositions that what is the effect of acquittal on a.
There is no mention. It is that is disciplinary person is pending. He is acquitted.
Yes, if your Lordships, he's been saying that throughout. He's been saying that I preferred an appeal after 12 years, which is not correct. If your Lordship kindly comes to page 92.
Yes, 8599. Yes, in that.
And the departmental proceeding can't end taking away my right of appeal. It doesn't. It's talking about a final order.
What is the statutory period for making an appeal?
1 month. I have done it.
Where is that? Where is that? Where is the provision?
1 month or 3 months, I think.
Normally in the service regulations,
it's usually 1 month or
45 days.
Yes, 45 days.
Normally 45 days, but it may vary and differ.
My books are with your Lordships. Anyone, actually. Appeal কত দিন?
Decided against the
Yes, sir, you are for the bank. You tell us. Where is the service regulation that you will not find in a bipartite settlement? You will find it in the bank service regulation. That period you will not find in the bipartite settlement. The bank must have a service regulation framed by the.
45 days.
Normally it is 45. Which provision? Which regulation of which year? 2014 regulation.
It doesn't.
There's the workmen in bipartite settlement, Lordship, officers regarding the officers regulation.
Oh, he is a workman.
He's a workman. That is why, Lordship, we have raised this point of the workman. And we have never challenged.
He was on which
Yes,
post?
Lordship. That is the under
He was on which post?
the clerk, Lordship. Clerk subsequently cashier, Lordship. And as per section
That was
18,
taken, but the
18 of the Industrial Disputes Act, Lordship, that
the,
was governed
Learned
by the Industrial Disputes Act.
Learned
But subsequently, Lordship,
the honorable judge has allowed that. She's entertained the writ petition.
Under 18.3, the
18
bipartite
Lordship.
settlement is binding on the parties to the settlement. So therefore, there is an option.
There is a
There is an option.
But the
We may in appropriate case exercise it. There is no absolute bar. But
falling from premier.
it may have better been taken up before the tribunal
Lordship.
to give him a better option. But if he has, because the nature of submission that he is making, he does not want to go into the merits of the proceeding.
Yeah.
He is saying the effect of this is you put me back. That's all.
And Millard, one more thing was said.
Anything else you want to show?
আর কিছু দেখানো হয়েছে তো দেখি। একটা
Can you give us copies
Yes, Millard,
of that entire settlement? Not one page.
No, I'm giving you because this is what I means depend on. On the last occasion, I have lost a book of this. I've already lost a book. So this is the last one I've got. Millard, I'll tell your lordship the page number. It's I think 420, I think. Millard, if your lordship kindly gives it to me, I'll take it.
এটা নেই
ঠিক আছে ওর 45 ডেজই হবে রে বাবা
This point was argued before the honorable single judge.
Yes, this was the only argument which I made. And one more thing, Millard, what he's been saying that in the criminal trial, the same set of witnesses, and they've never said that it was not the same. The charges were the same. They've never denied that. In their opposition, they've never denied that.
No, he has not said anything.
No, he's not said that.
Today also he has not. We have stopped him from saying anything like that.
And in fact, Millard,
He's only saying that this term does not apply to you. That's all he said.
In fact, Millard, the special judge has held that these the witnesses have got nothing to say.
Sir, he has not addressed on this point.
Yes.
He has not addressed on this
Because
point.
he was saying that separate.
No, we stopped him.
Yes.
You were
That-
sitting here,
if your
we
lordship-
stopped him.
If your lordships accept that, then.
Because you have confined your
Yes.
submission, therefore we have
Absolutely.
confined his submission. Now let us see where your submission is recorded before the large single judge. In which page?
Millard, page.
Which paragraph you have raised this
Your
point?
lordship kindly comes to
The consequence of 3C.
5. It starts from 5.
Three C appears not to have been referred also before the honorable single, let alone any submission we made.
Which this clause, Millard?
Yeah.
It has been. It has been.
Please show, we are trying to find.
বলা আছে yes Milord, that is paragraph 11. Yes, paragraph 11. Yeah.
Finding.
Yes. You take, that's all, take down.
Within 60 days, Lords.
Item number 2,
My lord, I appear for the appellant, my lord.
My lord,
Mr. Partho Ghosh is appearing on the other side. He is not today.
my lord,
Here, my lord, he is not here, my lord. May I only beseech your lordship?
I am only coming from not today, lordship.
No,
Only lordship.
only appeal, my lord. It's, my lord, accompanied by an application for condonation of delay. That can be taken up today, my lord.
My lord,
What is the order under challenge?
The order under challenge is the grant of MMCC, my lord, but it's on a different point. I have challenged. The point is very small, my lord, but it's not the regular.
What is it? Tell us. That's why we are asking.
Because
We
my lord,
know
here-
you are appearing in the other matters, therefore we are asking.
Yes, my lord. Here what happened, my lord, a person died. Now, after her death, my lord, the employment was claimed by the son. And all other dependents, my lord, they endorsed their no objection. Employment was offered. Not offered, my lord, not employment was provided. Appointment letter is there, my lord. Employment was provided. He accepted, but he didn't join. 10 years thereafter, my lord, the daughter of the person who died, she claimed for employment. Now her brother, to whom the employment was provided, he said, you give it to him. My lord, it was processed. It was processed on behalf of the ECL, my lord, to some extent. But ultimately, it was not given. Now, thereafter, my lord, in 2025, they preferred a writ petition, which was allowed in terms that let MMCC be paid from a particular date. This is the case, my lord. This is the fact in nutshell.
What is the delay? How many days?
A delay of 74 days, my lord. Delay of 74 days.
my lord, can it be taken up on
No,
tomorrow, lordship?
Not in. If he is not here, then
My lord, on Thursday.
we asked him, perhaps he would have instructed that if the condonation is allowed, it can be.
Very good, my lord. Will be on Thursday, my lord.
Thursday?
Lordship, yes, your lordship.
Huh?
Yes, your lordship.
Next Thursday, not this Thursday, next week Thursday.
If your lordship is pleased to pass any order or.
Yes, yes.
Great.
Today is Tuesday. What's the date? Next Thursday, what is the date?
My lord, today we are on 11th, 18th,
20th, lordship.
20th.
20th.
An adjournment is sought on behalf of the learned advocate.
Item number 3,
Number 3 is a contempt application, my lord. Already payment has been made.
In factual?
Yes.
Yes.
My lord, contempt no order was passed.
What is the date of payment?
And
What is the date of payment?
my lord, date of the order, yes, lordship, my lord, on 2nd April 2026, but bench is separate, my lord, your lordship.
order passed by
That's why it is not.
The
Justice for his.
the learned
Item number 14.
I am for the petitioner, my lord.
State
It is not there, my lord. I am filing the reply. I have already.
State
served
is
the
there.
copy. I have already served the copy of the reply to this.
You want us to understand what you are saying, then please use the mic. We can't hear you.
Lordship, learned AGP is appearing with Mrs. Runu Mukherjee, and Runu Mukherjee is not appearing today, is not present, and Mrs. AGP is appearing on in court number 236 on 2 p.m. matter. Lordship.
Then, my lord, kindly make it not today and not tomorrow, my lord. Tomorrow is fine. Would your lordship be pleased to take it the affidavit in
The
reply of
reply
paper?
affidavit in reply.
Item number 15.
My lord, your lordship has heard me on yesterday. My lord, your lordship is supposed to pass the order. For that matter, your lordship was, I mean, placed under suspension from 2019, 15, 17.
We heard you.
Yes, yesterday, your lordship has heard me the last fag end of the day, my lord.
Yesterday.
Yesterday, my lord. My lord, I am placed under suspension from 15th of July 2019, and my lord, I will be banking on more the government orders.
Oh, yes, yes. Now we remember. Where is that
Right, it's with my
memorandum?
It's with my reply. There's only one annex here, my lord, that is the memorandum.
There's a memo 9266.
Yes, 9266.
Where is it?
My lord, your lordship will find it
In your reply.
in my reply. Only annexes were made in my reply. And my lord,
Yes, you Repetition is accordingly allowed.
Item 16.
My lord, in this matter, I appear on behalf of the state, my lord. I have already received the instructions. By your lordship's direction was to file an affidavit, my lord. My lord, gives us 1 week time, my lord. We'll come up with an affidavit. We have already contacted the
Land
concerned person.
AGP submits that.
My lord, in item 16, I am appearing in virtual mode, my lord. My presence be recorded.
Strike off, none appears for the report.
Grateful, my lord.
Item 17.
I appear on behalf of the petitioner. The short point which is involved in the present application is that the writ petitioner, he was appointed on compassionate ground as a burglary boy in the office of the Superintendent of Police, Murshidabad. He continued for a considerable period.
What he was appointed as?
A burglary boy.
Burglary.
Constable, similar to constable. In 1984.
Yes.
Now, after serving in the post for a considerable period, he filed an application before
The name of the post rhymes with something quite opposite. Yes.
So he take out an application before the West Bengal Administrative Tribunal. The tribunal directed the Superintendent of Police to consider my representation for permanent absorption.
How long he continued? How long he was serving?
Still, I am continuing. My date of superannuation is October 2026. Now, that order was not carried out. I could not file the contempt within due time. I filed another original application. This application was disposed of in 2021, directing the Superintendent of Police to consider my representation. Now, since the order was not complied with, I take out an application for contempt. Now, during the contempt application pending, I was given permanent appointment, but an undertaking was obtained from me that I will not claim for the back wages. In 2023, I was given permanent appointment.
Date?
With
just give that date.
Yes. So, 24th January 2023. That is the order issued. Thereby, the appointment was given.
Page, sir.
Page 28 of the Your Lordship's bid. Lordship will kindly excuse me if the copy in my copy it is some illegible. May I just read it for Your Lordship?
Oh, we have it. We'll go through. Just give us more.
Lordship.
My boggler. So, how you are aggrieved by this order?
No, Lordship, the aggrieved by this order, this undertaking which my employer obtained from me, Lordship is well aware. There are certain judgments that at that point of time, I was not in bargainable position. My employer, he compelled me to submit an undertaking out of compulsion because at that point of time, I was receiving some meager amount on contractual basis. This my appointment was given from October 1984 on notional basis. But the thing is, Lordship, I have actually served the office of the Superintendent of Police. I have discharged my duties. It is not the case of punishment that I will forego my back wages. If your Lordship only consider that I will not claim the back wages, and from the date of passing of this order, I will be entitled to the benefit like a regular employee. Now, Lordship, since it was not on the basis of any punishment that order was passed, they cannot deny the back wages for the period I have served the office of the Superintendent of Police.
They are not denying back wages. They are denying you salary as a regular employee. Whatever you got, you have got.
Yes, that was on
How you
contractual
can-
basis.
We don't know. You have worked on your own volition. You were not forced into that work. So on what basis you can claim the benefit of regularization for 4 decades back? Let us see this law. You sure?
I have discharged my duties on.
Now you are repeating.
Yes.
Everything said and done, you have to show us that these 4 decades you can claim the salary of a regular employee.
No,
Where
Lordship,
where is
so
the-
far as the back wages is concerned.
No, it's not an issue of back wages. Back wages means due. You are seeking extension of the regularization for the purposes of a regular salary from 1984. Under which law?
That is my claim.
That is not a back
If
wage.
your Lordship kindly consider.
Please read what a back wages is. Back wages is for duty performed under a specific status. For the status in which you perform the duty, you have got everything. Now you want extension of this new status to back 40 years. Under which law? Just show us. Where is that?
I have been given benefit notionally. I
That's
want
why we are
actual
saying
benefit.
we are finding it rather surprising.
Notionally.
That is why we asked you what is your grievance, because in every case they are giving a regularization but not giving the benefit of the past service. And they are all coming. You have been given from 84.
Yes, notional benefit I have been
From
given.
84. So you will get a full pension. You will get a full pension.
My seniority would be counted from the date of my initial.
First that
undertaking.
Prior to being born in the cadre, you can get any benefit, show us a law.
Lordship, now they are harping on the undertaking because which I have submitted.
Forget the undertaking. We are ignoring the undertaking. Prior to being born in a cadre, you can get any benefit of the cadre or service. Show us a law. Any judgment. It will be difficult, sir. You will
Sir,
not get it.
I could obtain certain judgment on the back wages as well as the
No, it's not the issue.
undertaking. That is,
You want
they cannot use this undertaking as their way
We are ignoring it.
benefit.
We are ignoring it. We are telling you we are ignoring it. Take it that the undertaking is not there. Then how you will get a salary for a cadre in which you are not even born prior to issuance of this order?
Lordship, my representation to that effect is pending. Your Lordship can direct the authority to consider my representation.
See,
That is a part of
we don't want to generate a litigation. Your client should know where he stands. You show us the law, we can, if you are able to convince us, he will get. If you are not able to convince us, he will not get. We will not give him a false hope and make a representation and then come back again. We can say you may pursue. We will not pass any direction. If you want to pursue, you may pursue. No case, sir. Law is settled from direct recruit engineer's decision in the 70s rendered by the Supreme Court that prior to a birth in a cadre, you cannot get anything. They have been kind to you. I don't know. Maybe you must have rendered very good service. That
for the notional benefit.
Yes, you will get a full pension. Every day today also we have taken up. They have regularized.
But from the initial.
No. I'm telling you, 2 months, 27 days short of 10 years. And he is not getting even the minimum pension, and he was working prior to regularization for decades. We will say you pursue your representation. That is at best what we can say.
Lordship, kindly give me a week's time. Let me.
After some argument, learned advocate for
Item number 18.
Item number 18, I have called a petition, my lord, led by Mr. Divyendra Chaudhary, before your lordship through virtual mode, my lord.
Yes. But in item number 18, my lord, I am praying for only not today, my lord. Because I had a matter in Supreme Court, my lord, just now make it not today. Make it not today, my lord. I will submit before your lordship tomorrow, my lord.
18 and 19. 18, 19.
Not 18, 19,
22, 23, 24. 24 now, 24.
what is the issue? What is the issue?
18 and 19, he has to satisfy with regard to limitation. Or we say appointment to the post of QP. He was contacted by legal newspaper Supreme Court. But they have filed a 2018 recruitment was over. They filed
I have to satisfy before your lordships on the point of delay. I will. Tomorrow, my lord. Kindly take the matter tomorrow. I will.
Tomorrow with not today, it will come.
Obliged. Obliged. Get to money.
Yes, you have a difficulty.
Obliged. Get to.
He will come today and he will start arguing tomorrow. Let him come day after. Yes.
No, my lord, tomorrow. Why today? Return back, my lord.
Tomorrow with not.
Tomorrow is similar matter, my lord.
18, 19.
18, 19, 22, 23, 24.
18, 19, 22, 23, 24.
22, 23, 24.
Get money. Get.
Item number 20.
But 20, my lord, I will be paying, my lord, not this week, not 2 weeks, my lord. We say good to see you. With consent, my lord, let that be after 2 weeks, my lord.
That's great.
Great.
25th August.
25th. तो क्या चल रहा है और
My lord, can it be month of September, my lord?
Give us a date.
Any day, my lord, start. Any day from first week of September.
First week of September, any day, my lord.
Give the date. The moment we'll say, you will say not this date, that you give the date.
That's September 3rd. 2nd September, 3rd September.
Second. We know.
2nd September.
Item number 21.
Mr. Surjonil Das, learned AGP is appearing in this matter for the state, my lord. I'm just praying for an adjournment, my lord.
None of yes. Give your appearance. Give your appearance. Please, sir. Please, where is it? Item number 25.
Last officer, my lord, was directed to file an amendment application. But it is not ready, my lord. I'm praying not this week, my lord. Also the bulk one, my lord. Amendment application.
The time granted by the earlier order dated
For this, 25th August.
Item number 26.
Yeah. After this, when I was determination, I had never done criminal appeal hearing. Once. Just.
Yes, sir.
Madam, this is the matter regarding Malat tribunal which is pending long, and then Malat came before your lordship.
Where is the way?
Way is the last page, the order, Malat. Several order has been passed, but no material, only adjournment, other things, Malat. Last page, Malat, that is the last order.
What is the date of filing of the OA?
Date of the filing of the OA, that is
309 of 25.
yes, Malat, that is 309 of 25.
What is the date of filing?
Date of filing, Malat,
Your verification does not contain anything. Case 36.
yes, that is true, that is not written. I think that is January 25, I think, because after.
We think not. 309 cannot be in January 25. Cannot be, sir.
Maybe April or.
Maybe not. We need to know the date. Whether it was filed prior to September or after September. If it was filed after September, you will have to go before the Honorable Single Judge dealing with service matters. If it was filed prior thereto, then we will take it up.
No, Malat, you will see kindly come to the order, first order, Malat. That is, you will see page 28.
All right, so it is June.
Yes.
Yes, proceed. What is the issue?
This is the matter, this is small issue, Malat. Actually, what happened in the year 2001, my client has, Malat, applied for, Malat, for the post lower division clerk in the department social welfare, Malat. And he was selected and subsequently joined before the said post. But something somehow, Malat, in the year 2022, Malat.
16/2002 order. Where is the 16/2002?
That is the order, Malat.
Where is that reason order 16/2002?
Yes, Malat. Reason order and subsequent, Malat, order passed by the, Malat, director, Malat. That is, Malat, page.
So after 16/2002, another order has been passed.
Yes.
Where is that order?
That is, Malat, page 59. And then reason order.
Page 59.
So that is just Chairman Soumitra Pal. OA 382 of 2020. Is order dated 8th of July 2022.
After this order of 16/22, another order has been passed by the authorities.
Yes, sir.
Where is that order?
That is authority's order, my lord. 24/11/2021, my lord. Page 60, my lord.
24/11?
A6, my lord.
Can you hear us? Third time we are asking you.
I try to assist.
No, you are not able to hear us, then how you can assist us? Third time we are asking you.
There are several orders. That
Any order has been passed by the authority after 1/6/22. You are repeatedly saying yes. That order has been passed by the authority after 1/6/22. Where is that order?
So this is 1/6/22. As soon as the
No, my lord. That is, my lord, order passed by the, my lord, tribunal. That is 24th of November 2021. That order.
Can you understand what we are saying? Whether any order has been passed after June 22, you are showing us 21.
June 22.
You're not listening to us. We have to ask you the same thing 4 times before you give a response. Because initially when we said, you said yes, some other order has been passed. We are not able to find any order after 1/6/22. But you said some other order has been passed. Where is that other order? Everything you have to say no. If we say
That is which my lord, this order, the authorities order, which impugned order has been challenged, my lord. That is, my lord, page 60, my lord.
oh, that is 1/6/22.
Yes.
At the very outset, we asked you. You said no order has been passed.
Sorry, my lord. That is my mistake.
Wastage of time. Yes.
That is reason order on.
Now let us go through that,
Yes.
please.
order আছে তারপরে এই যে এইটা 117/2023 এটা ফাইল করেছিল হ্যাঁ হ্যাঁ
Yes, what is wrong with this order?
This is not wrong, my lord, but subsequently, my lord, the appointment letter, my lord, that is order passed by the, my lord, director, my lord, the Ajay, next page, my lord. Balurghat, Dakshin Dinajpur, directed to report the child development project officers could be her scale of pay ato with grade 2006 class allowance corresponding to pay scale ato as per RUPA 2019 annual from time to time date of joining to the post. So, Malad, that my experience and other things, Malad, as far as joining is concerned, Malad, that is the.
When did you make a claim for the past benefit? Where is your claim for past benefit?
Immediately thereafter, after getting appointment, Malad, the appointment. Immediately thereafter, Malad, I made the application before the authority, but that may be considered, Malad. My seniority, Malad, only. So they are admitting, Malad, that I personally feel that Sri Sarkar was denied the opportunity of getting employment without his fault at the first instance. So no, I have no problem because of non-joining.
Where is your claim for the past benefit?
Yes, not benefit, but seniority also, Malad. Because
where is the claim?
Claim means, Malad, I made representation, Malad. So director, Malad, next page, Malad, that is page 66. Next page, Malad.
66 is there.
Immediately, Malad.
Page 66.
Yes, 66. The representation dated 24th of January 2023, Malad. And then, Malad, Bengali, Malad, that is to the local CDPO, Malad. Next application, Malad. So that is not my fault, Malad.
No final order. 6 months from that has expired. 6 months. Of that. Yes. Come to section 21, 2B and 22B and section 21 of the Administrative Tribunals Act. How your application is maintainable before the tribunal? Yes, tell us.
Maintainable as far as maintainability is concerned, my lord, that is always, my lord, because, my lord, it is pending, several order has been pending, and then, my lord,
Please tell us on the maintainability issue.
rejection on the part of, my lord, that
tribunal, my lord, several times, my lord, for praying, my lord, interim order and disposing of the matter, my lord. From the date of, my lord, filing this application till date, my lord.
Sir, we are asking you to address with reference to section 20 and 21. You are not addressing anything.
I am only my prayer is that, my lord, consider my representation.
You pursue your representation. We will not create a cause of action in a dead matter. We are being very clear.
That is not functioning. That is the main question.
That is not the main question. The main question is when you approach the Act.
Yes.
Did you approach it within the prescribed period under the Tribunals Act or did you not? Only then comes the issue that tribunal is not functioning.
As far as prescribed act is concerned, my lord, this petition, my lord, filed after, my lord, joining the issue because they are joined, my lord, as a, my lord, after 2019 entry. But my client is, my lord, joined, my lord, 2001, my lord.
That's all?
Yes, my lord.
Take down. Heard the learned advocate for the to file afresh. Forget it.
Kindly. Otherwise, my lord, it will not, because tribunal is functioning, so my lord, kindly.
Your client is not learning. What can we do?
That is true.
Your client is not learning. Yes, call the next.
Kindly, my lord, Vivati maybe. Because
At the last record, the learned advocate.
Item number 27.
I'm appearing on behalf of the
শুরু করে বলা যাচ্ছে, বলা বলছি শেষ কর, নতুন জজ এসছে, নতুন জজ সাহেব, নতুন কর।
all of this appeal is arising out of the order in connection with the disciplinary proceedings.
But he has to argue fresh because my lord Justice Rai, my lord, because Justice Bishwash and your lordship. His lordship is telling something, my lordship.
Mr. Basu.
In July.
In July, your lordship was pleased to direct us to file paper book. We have filed.
You have filed it.
Lordship.
That matter which you.
My lord, no, that is different matter. That is a transport matter. Here, my lord,
Paper book.
paper book. ডিপার্টমেন্টে ফাইল করেছে পেপার বুক কোথায় ফাইল করেছেন সেটা জানেন না কি পেপার বুকটা কোর্টে ফাইল করেছেন না কি বলে করে
Can you give us details when it has been filed?
সেটা বুঝতে পারো ফাইলই করে দেবেন must not file.
Oh, it is not filed.
No.
Everyone is overawed.
দেখুন
We can, because we have to start afresh today.
Yes.
We can start.
Yes, my lord, we succeeded, my lord, in the because trial court, my lord, a disciplinary proceeding was initiated against my client bank. Now, my lord, one.
Inform us. Yes.
My lord, we're challenging, my lord,
What is that punishment awarded? Dismissal?
punishment is dismissed.
So that was set aside.
Yes.
That has been settled.
Consequential relief also.
Yes.
Yes.
Very good.
My lord, my limb of argument is first is he is an award staff. Yeah, he is an award staff. Therefore, he has an adequate alternative remedy before the ID Act.
because both the parties can lay evidence before the tribunal if there is any defective.
Within the limit of scrutiny.
Yes, yes, my lord. But both the parties can lay evidence before the tribunal if there is any kind of defective inquiry. Second thing, my lord, though the my lord, the disciplinary authority passed the order on 28 September 2013, and appellate authority passed the order 31st December 2014. He challenged the writ petition after 5 years, 2018, July 2008. And he has never said, my lord, third limb of argument, he never said that he is not guilty of charges. He says that punishment is disproportionate. I'll show your lordship that relevant portion also. And so far the bank.
This aspect was considered by the learned single judge.
So far
the issue of delay, you raised it before the learned single judge.
That has not been taken into consideration. And so far the bank employees is
yes.
Bank employees is concerned, my lord. Trust and credence are the paramount consideration.
Yes.
And trust and credence are the paramount consideration.
High degree of integrity, devotion, and dedication to duty for dealing with public money.
So far the charge sheet is concerned, charge made in account of operating form. My lord, your lordship may remember.
What is? Please tell us first. What is, according to you, what is the infirmity of the judgment which you are assuming before us, which is pending consideration in the intra-court appeal? What has been done by the learned single judge, which according to you could not have been done? Because obviously you did not raise an issue of delay in latches. So delay in latches was not raised, not considered. So after that, let's see what else.
201. 201. Order impute.
So let us just read the judgment cursorily, and then we'll give us 5 minutes, 7 minutes.
My answer is, my lord, at page 210. The crash of the defense is set out in the affidavit in opposition duly.
Please have some patience. Be kind to us. Yes.
And have some faith also.
Yes.
delay point.
No. Yes, so your inquiry officer's report is the basis of everything. The inquiry officer's report is neither in dispute by you nor by him.
Point of delay has been raised. My lord, kindly come to page 212.
No, first thing we are trying to clarify that the findings of the inquiry officer is not in dispute. Neither you have disputed the finding, your disciplinary authority did not disagree with finding of the inquiry officer, nor he is saying that the finding is bad. So therefore, what is the effect of the finding? That is the limited scope. Where is the finding of the inquiry officer? If we have considered correctly, that is 96. That is the case. So, mistake, sans, negligence or intention. What is the effect?
And Millard, the bank did not suffer any loss either in the form of reputation or financial loss. And number two, Millard, the bank, a gratuity, Millard, that was withheld, and ultimately to approach the gratuity court under section 75 of the Gratuity Act, that was released. I came before your lordship's court.
Then you came in the writ proceeding.
Yes. I did not have any money, Millard. Nothing.
Only when he got the money, then he came.
Yes, in a way. Millard, that is a ground reality, Millard. That is a ground reality.
That's why then only he came. Yes.
Don't lend your lordship ears to the other honorable judge. On this code only, when it is between Millard, his lordship and I, Millard. Yes.
Page 96. Report.
I will forget everything. Don't do this.
In terms of letter number such and such dated 7th September 2018 of the disciplinary authority, Zonal Manager, Kolkata Zone, 96. I was appointed as inquiry officer to inquire into the charges leveled against Sri Indranath Mukherjee, EMP number such and such, Special Assistant UCO Bank, Hastings Branch, by charge sheet dated 29th August 2013. Sri Anjan Kumar Ghosh, Manager Zonal Office, was appointed as the presenting officer by order dated 7th September 2013. The first hearing in respect of the said charge sheet was held on 12th September 2013, and thereafter second hearing was held on 16th September 2013. The hearing was concluded on 16th September 2013 itself. Presenting officer was directed to submit his written brief by 20th September 2013, and charge sheeted employee was also directed to submit his written brief by 20th September 2013. Both of them have since submitted their written brief to the undersigned. As per charge sheet, Sri Indranath Mukherjee was charged with the following gross misconduct: doing any act prejudicial to the interest of bank, or gross negligence, or negligence involving or likely to involve the bank in serious loss.
Yes, action taken on the inquiry report. Where is the relevant provision in the bank's regulation?
Regulation.
Must be giving three options: to accept, to disagree, or to direct for further inquiry.
Clause 5, my lord. The expression আরেকটা copy. দুটো কপি তো আরেকটা যশারের জন্য লাগবে তো।
You have legible copies? 2 copies? Come tomorrow, get 2 copies.
Day after then.
Day after. The finding is mutually destructive. The two findings are mutually destructive and such finding has been accepted by the disciplinary authority.
Himself has admitted that he has never stated that he is not guilty. He has stated that it is disproportionate punishment. Kindly appreciate it.
No, before the inquiry officer, he has taken a stand that look, in the daily discharge of duties, many of the things are signed in good faith. A form was placed before me, I have signed it. So he has owned what he has done. He has said it was with no malintention. That apparently was accepted by the inquiry officer, who said that yes, no intention can be gathered, no loss has been attributed. So he says, I find the charges proof. And now,
he says that
at that stage, you have the option as a disciplinary authority.
he says that even
To say that conduct a further inquiry, you have not examined things properly, or you could have disagreed that I disagree with this finding, that there is no intention, because intention can be gathered based on the material on record. Therefore, we want to see that provision, action taken on the inquiry.
I have to answer to another matter. I have to answer.
Yes, in every matter you have to answer something.
He says it is a negligence, but not deliberate negligence.
No, my lord, he has missed one point, page 180, 182 of the report, where my lord Mr. Mukherjee, who allegation was very severe and specific, that he is the mastermind, he has done everything, and my lord, he was exonerated from all.
Anything on record to show that the form was changed? Or anything to show that the form was changed or manipulated?
Yes, my lord, supposed to what, I will in the next, let him submit. I will take advantage.
Okay, dismiss করা হচ্ছে.
Yes.
He was also dismissed.
I pointed out, I will show. Same proceedings, I will show. The graver charges. And he is the mastermind.
Paper books filed are taken on.
He
had to wait to get his gratuity before he could come to the high school.
What can be done? When your lordship, kindly do not hear him at particularly when it is between the bench.
Yes.
Item number 28.
My lord, in this matter, I am on behalf of the respondent, my lord. My lord, they are not tampering. Since last three occasional days, they are not tampering, my lord.
We'll just see.
My lord, if you allow me, I can assist you in this case, my lord.
If the petitioner is not appearing, what you will assist us?
My lord, I am suffering from irreparable loss and injury, my lord. There is no case itself. The prosecution rested on surmises and conjectures.
Prosecution they appeared.
Prior to that. Yes. And before that, they have filed the paper. It's okay. Is there any interim order?
Yes, my lord, they are enjoying their interim order since
Which
2018.
order? Date of the order?
Yes, my lord, I'm just telling you the
13
date and page number of the order.
11
2 minutes time, my lord. These are
by the to have the direction for reinstatement of the respondent state. Portion of the interest that the student state and for the others. 13
in volume 2, my lord. The order starts from 180. The judgments which here it is shown, my lord, I have other judgments to supersede.
On Friday. Today again, there
Lordship passed an order, my lord, to serve a copy, my lord. He has only served the memorandum of appeal, but the two applications are there. Copies whereof have not been served.
let us see the last order. We are informed by the learned